Your thought here, 150 witnesses. What kind of a timeline are we talking about? It was floated this might last 4 weeks. Is that possible?
I think that the prosecutor said 4 months, if I'm not mistaken. But the judge...
Yes, 4 months.
Yes. The judge expressed skepticism about whether that was realistic, and he indicated he thought it could be double that, especially if you had 19 defendants on trial. I thought the judge displayed his own experience as a trial lawyer. He's a former prosecutor, and he was clearly aware of the ways in which having 19 defense attorneys could slow things down, because even if the state is going to be presenting the same 150 witnesses, let's say, in its case in chief, no matter how many defendants are on trial, each of those defense attorneys could potentially cross-examine those witnesses called by the prosecution. They also may have their own witnesses and other evidence that they want to bring into the trial. They're going to have motions to bring, and they'll have to be argued and decided by the judge. And they're going to have arguments to present to the jury. And so the involvement of those other attorneys is inevitably going to slow things down. So it does seem that the projection by the district attorney may have been too optimistic, and you see the judge weighing very carefully what he thinks independently is actually the timeline for trying a case of this magnitude with this many defendants potentially involved.
It's also how it gets tried. We know that the district attorney, Fani Willis, wants to keep all these individuals together to talk about a criminal enterprise, in her words. Is that possible, or are they going to have to start to be tried separately?
Well, that was the matter before the judge today, at least with respect to the two defendants who had moved for a speedy trial, Ken Chesborough and Sidney Powell. They had each asked for a speedy trial, as they are entitled to, but then they also asked to be severed from one another. They didn't want to be tried together. And the judge was hearing argument on that particular issue today. And he was asking really pointed questions of the defense attorneys about how exactly their clients would be prejudiced by being tried together. And he ultimately denied the motions to sever one from the other, finding that the lawyers really didn't articulate how those two individuals would be prejudiced by being tried together. He deferred decision on whether he's going to actually include in that trial that he's now scheduled for October 23rd for those two defendants, all of the other defendants. He's clearly mindful of just what an administrative difficulty that would be to do all 19 together. He's also mindful of the fact that you have a pending motion. There's a pending motion in federal court to remove the case of Mark Meadows. There's several other defendants who've moved to have their cases removed to federal court, and how, depending on what the outcome is of those motions, there may be some defendants who are in fact taken out of his courtroom in the state courthouse and to federal court, and potentially even all of them, if the ruling is that they should all go together to federal court. That would really have an effect on what his ruling is and his schedule for the trial before him. So things are very contingent at this point.
We understand, if I can pivot to a separate case here, Jessica, the case involving Hunter Biden. The special counsel David Weiss tells the court, and this is a pretty amazing headline here, that the U.S. prosecutor will seek to indict Hunter Biden in September this month. We're talking about another indictment. How often do we get a heads up like this, and what do you expect will follow?
I didn't find this to be all that surprising as a news item today. Once the plea agreement had fallen apart, as we saw, that was quite dramatic and unexpected. But once that happened, the logical next step, if in fact the plea negotiations had broken down, was for the prosecutors to file an indictment with the charges that they had filed initially, part of an information, which would be getting rid of the necessity of an indictment by a grand jury against Hunter Biden. So I didn't find this news all that surprising. This is the logical next step, that it would sort of head in this direction. There would be an indictment. It would be scheduled for a trial, and the parties may attempt again to come to a negotiated disposition. But the fact that the prosecutor is saying he's going to file an indictment shortly, or seek one before a grand jury, is not all that surprising and doesn't indicate anything particularly new at this juncture.
Well, he entered that agreement, and under that, he had agreed in principle to plead guilty to federal charges. Do you expect in this indictment for Hunter Biden to plead guilty?
I think at this point it's too soon to say. I mean, his willingness to plead guilty was contingent on him receiving the benefits of the plea agreement that at that point had been negotiated by the prosecutor with his attorneys. What emerged at the hearing before the Delaware District Court judge, who was to take his plea subject to that agreement, was that there really had not been a meeting of the minds between Hunter Biden and the government about the terms of that negotiated plea agreement, and especially what immunity, if any, he was being given for other potential crimes that had been under investigation. They really had not ironed that out, and the judge picked up on that and was concerned that if she accepted his plea at that point, pursuant to the agreement, there might later be litigation in an effort to actually take back his guilty plea, because he would have argued that it was not voluntarily entered because he didn't actually understand the terms of the plea. So I think at this point we don't know if it would be heading for trial or if in fact they will reach a new agreement pursuant to which he would enter a guilty plea.